Before I describe Treasury's interactions with the IG related to this audit, it is important to underscore two critical points. First, there is no indication that Treasury was involved in the improper conduct at the IRS. The IG report did not find any evidence that Treasury or others outside the IRS had any role. Mr. George confirmed this point in his testimony before the Ways and Means Committee last Friday and before the Senate Finance Committee yesterday. Second, the improper conduct already had ended by the time Mr. George informed Treasury of the fact of his audit. Mr. George's report states that the improper conduct ended in May 2012. Mr. George has testified that he first notified Treasury of the fact that he was conducting an audit in June of 2012. At some point in 2012, though I do not recall precisely when, Mr. George notified me, at his initiative, that he had undertaken an audit of the IRS's review of tax-exempt applications. He told me only of the fact that he had undertaken such an audit and did not provide any findings. That
comment that I've never heard is defense of not knowing, and I'm disappointed. I'm going to go through a line of questioning primarily with Mr. George. Mr. George, before the Ways and Means Committee, you told Representative Danny Davis the following. Our audit, sir, began with the request of congressional staff in what I want to give you I want to give you the exact date, sir. I do not have it here. March 1st of 2012 is when there was an initial contact with the Government Reform and Oversight Committee and our audit began, or roughly, and then you go on with May or March, et cetera, et cetera. So essentially, this began in your mind when you were made aware of it in March of 2012 by members of my committee, staff members of my committee, correct?
Yes.
So, oddly enough, we have with us, and put it up on the board, from Holly Paz, a document just released to us, I guess in preparation for yesterday's interview, that says, forward TIGTA document requests, the following are issues that could indicate a case to be considered a potential Tea Party case and sent for secondary screening. 1, Tea Party Patriots of 912 Project. 2, or number 4, statements in the case file that are critical of how the country is being run. Now, that's May 20th of 2013. To your knowledge, is that that is essentially the result of an internal investigation done by the IRS, not your investigation? I'm sorry. That's July 23rd. I'm looking at emails, which unfortunately are this year. But that's July 23rd, 2012. Is your understanding that the IRS concluded that they had wrongdoing through their own internal investigation by July 2012?
I have no information on that, but let me consult with my counsel. I can't. I have been informed that they conducted an internal review, sir, that was completed before that period.
Okay, so it's your testimony that, in fact, independent of your activity, Mr. Schulman's reports conducted and concluded wrongdoing and could have, in fact, reported that up the chain and taken appropriate action independent of your activities.
That is certainly an option, sir.
So, Mr. Schulman, before I go back to Mr. George, it was your watch. Your people did an internal review. How is it you did not know that things were rotten in your shop in time to not only make sure it stopped and stayed stopped, but in fact the Treasury, your boss sitting next to you, was aware of it?
You know, I've said that I learned about this sometime in the spring, and by this I mean I learned the fact that there was a list and the fact that Tea Party was on it.
Okay, so you knew at that time that you had mistreated Americans within your organization and saw no need to report it up the chain. Is that your testimony?
My testimony is that at that point, I had had a preliminary verbal report. I had been told at that same point that the activity was being stopped, and I was told that the IG was looking into the matter.
Stop there. I don't really care about the IG right now. The IG probably prompted the internal report. The IG, in fact, has been the reason that we didn't hear about this until long after the election, till months or actually a year had gone by. I'm asking you a question. It was your job to make sure people weren't abused. It was your job to stop abuse, but also to report it. Americans had been injured by the activity, wrongful activity of your organization. You say you got it vocal. I don't care that the IRS doesn't keep paperwork. I know when I have to pay my taxes, I don't do it based on what I say I made or what I say my deductions are, that I need paper. However, you knew you did not report up, or did you report up to anyone else within your chain?
I had some of the facts, not all of the facts. I had no idea of the scope and severity. I didn't know the full list. I didn't know who was on the list.
I'm not going to belabor that because I don't know has been your answer previously. I'm going to move back to the IG. Mr. George, September 24, 2012, committee staff mentioned your report would be ready in September. Now, these are exchanges we're putting up here that are back and forth. They're not all personally with you. So September 24, 2012, the answer to our request about this IG report was field work for this audit is still ongoing, meaning we don't get an answer. December 18, 2012, any update on this? Sorry for the delay response. I was studying for a final. Okay, that's when it was pushed off to March. These are staff. Committee staff just wanted to know, to check on the progress of this. This is February 12, 2013. Of this, are you at a point where you can schedule a briefing from your organization? We are leaving no stone unturned. This is February 22nd of 2013. We won't be able to provide a detailed, substantive briefing until late April, early May. My time is limited, so I'll put the rest in for the record. Mr. George, I could go on as late as May 9th, where the committee staff said on the 8th, can we go ahead and schedule a briefing? May 9th, I'll get back to you. And it goes on. Mr. George, this committee and the entire Congress has existing laws. Yesterday I spoke before all of your fellow IGs. Under existing law, you have a peer-level report of substantial misconduct or problems, including waste, fraud, and abuse. The Act describes your establishment, which meaning, in this case, the IRS, and Congress in the same sentence. On August 3rd, this committee, I sent you a letter explaining the 7-day rule, explaining the statute as it has been written for decades. You have a responsibility to keep us continuously and, according to statute, equally informed. In this case, it appears as though you certainly did not. Would you agree with that?
No, actually.
Okay, so when you conducted day after day after day with Mr. Schulman's subordinate, Ms. Paz, one after another interviews in which she's in the room, she's listening to all of these, you're doing that. You know at some time, and I'm going to close with just a question, on what day did you know, over this year period, did you know personally that in fact the IRS had abused Americans in the process of approval? What was that day? What was the aha moment? And didn't you have an obligation to report that to Congress at that time?
Mr. Chairman, I have a detailed timeline which goes from almost month to month as to the interactions that we had with your staff and then subsequently with the Commissioner as well as with officials at the Department of the Treasury. And I would appreciate the opportunity to give you a sampling of that.
We're going to accept that, and I just want to close, and then I'll let you take as much time as you need. If your timeline essentially says you kept us informed so we knew that, in fact, there was a pattern and could speak to Ways and Means to find out that hundreds of people, hundreds of organizations still languished not being approved, even after, quote, the abusive behavior began. They still didn't get their answer in a timely fashion. And if you're saying that you informed Mr. Woolen so that he would understand what was going on, or others at Treasury, and you informed us. And Mr. Schulman, here's my problem. Mr. Schulman has already said under oath he didn't know. Mr. Woolen has already said they didn't know. And although I'm not under oath, I have reviewed my committee staff documents, and of course it's a bipartisan relationship. We certainly did not have the information in any way, shape, or form that could be understood so that congressional action could occur until practically today.
Mr. Chairman, there are established procedures for conducting an audit, and once again, this is an audit. And to ensure fairness and to ensure that we are completely accurate with the information that we convey to Congress, we will not report information until the IRS has had an opportunity to take a look at it to ensure that we're not misstating facts.
Mr. George, that is not the statute. That is not the statute.
But it would be impractical for us to give you partial information which may not be accurate. It would be counterproductive, sir, if we were to do that.
Well, I appreciate that. I've taken a lot of time, and I'll give the same amount of time, of course, to my ranking member. But this committee, last August, made it very clear that the statute as written does not give you the ability to, or any IG, to use us as a whipping boy when you want to, and in fact keep us in the dark until an investigation is completed. Mr. Schulman, I will admonish you, as best I can as one member of government to a former member of government, that in fact there was a there. People in your own internal operation knew. If you didn't know, you were derelict in your duty, or your management style was such that you didn't get informed. Either way, that is certainly not something you should be proud of. To the extent that you did know or suspected, Mr. Woolen standing here or sitting here implying that Treasury didn't know is astounding. Mr. George, fact is, if these individuals did not know, that you did not allow them in a timely fashion to take corrective action, even while you continued with what could be a criminal investigation/audit. In the case of Congress, I will work with the ranking member to reiterate with clarity Congress's absolute right to have, according to the statute, continuous information, and that is not waiting for the final conclusion. The Act did not say audits and investigations shall, upon their conclusion 7 days after being given to the principal, be delivered. That is not the portion that we referred to in August of last year. I'll give you the last word.
Sir, I would welcome the opportunity to work with you and other members of Congress to clarify exactly what the quote-unquote 7-day rule is under the Inspector General Act. But once again, I think it would behoove all of us to ensure that accurate information is given to Congress so that we don't act precipitously. And as you, I'm sure, are aware, many times when information is conveyed to the Hill, it is sometimes not retained in the Hill, and on the Hill, rather. And that is not fair to the people who are investigating or
I apologize. I said I would give you the last word, but right now we're seeing an awful lot leaking out of the administration, and the IRS leaked in this particular case. This organization maliciously leaked this information. Mr. Woolen, the only other thing, and I apologize, Mr. Cummings, I'm going way past where I ordinarily would. It is our understanding that today, as we speak, dozens, if not hundreds, of applicants who have been waiting years are still being essentially denied justice. If they continue to be denied justice, every clock tick is a clock tick of you're not meeting your obligation. Mr. Schulman has left office. He left office without making sure that those, quote, Tea Party groups and others had a legitimate adjudication in a timely fashion, which means they were already overdue because of the prior abuse. To the extent that there's one applicant that comes forward to this committee that today has not been approved or denied for cause, you are now derelict in your duty. Mr. Cummings.